right, begin.
What's going on, y'all, and welcome back to the channel. I hope you guys wake up happy and healthy this morning. That's the most important thing. Now, before we go any further, I want to ask you guys a favor. If you don't mind, go ahead and punch that like button and also smash that share button so we can get this channel recognized, you dig? And also, if you're on Instagram, you can follow me there at NCToughTV. That's a for sure way that we can stay connected, all right? Now, with that said, let's go ahead and get down to business. So it's been put out there that Wendy is now suing Wells Fargo and her former financial advisor by the name of Lori Schiller. Now, Wells Fargo took it upon themselves, right, to freeze all of Wendy's accounts. And those accounts contain millions and millions upon millions of dollars. Now, Wells Fargo is trying to plead their case in this regard, right? They're stating that the reports that are surrounding Wendy and the fact that she may be suffering from early stages of dementia is the reason why they decided to freeze her accounts to protect Wendy from spending money and not knowing where the money is actually going, and also to protect Wendy from other people taking advantage of her and her finances. Now, before I go any further, right, what I want to do is read you something very interesting, or at least I found very interesting, that thesun.com posted on, their website and things of that nature. So it says, Wendy's attorney alleged that Wendy's former financial advisor advised the bank that Wendy was of an unsound mind and that Wells Fargo has denied her access to her bank accounts and statements. Wells Fargo has justified its decision to keep Wendy's accounts frozen by referencing its authority under various client agreements to pause or reject instructions for proposed transaction, pending judicial or administrative remedies, should they suspect financial exploitation, dementia, or undue influence, the petition claimed. The host legal team claims the bank has overreached in its authority, in part because Wendy has not proposed a transaction which should give the bank the discretion to pause or reject access to the accounts. Now, from the sounds of things, it seems that Wendy was well aware of the stipulations that were put in place within her client agreement, right? Because it clearly states that, if a person is suffering from financial exploitation or dementia, right, they have the right to pause and freeze the accounts to protect the account holder. Now, even though Wendy's lawyer said that Wendy has not made a suspicious purchase for, the bank to freeze her accounts, well, they may be just trying to prevent her from making a mistake as such. Now, I may have an unpopular opinion, right? I understand that Wendy has bills, right? But listen, these people are not going to, kick Wendy out of her $4.5 million penthouse in New York City. Her people are going to get paid. They know that Wendy has the money. It's just the issue that they're having with the institution, the banking institution. So let's be real about that. Another thing that I want to state is that I know that her son is the power of attorney. But listen, I don't even trust him, to be honest. So in my estimation, I'm glad that Wendy had to go about it this way. Because those of you who follow me tight, you know that I've questioned her son's behavior, for about 2 years now. The fact that he's flying out to Los Angeles and Florida, having a good old great time while his mom is laid up in New York City at the particular time, battling for her life. And so for me, that's unprincipled and fickle behavior on the part of Kevin Jr., and he's not to be trusted in my estimation. Now, people are saying that they're trying to steal Wendy's money. I'm pretty sure that she has records of, previous bank statements of how much money she has. So I don't necessarily deem that to be true. And they also say that, Wendy can't view, her bank accounts and things of that nature. Again, I'm pretty sure that she has previous statements to give her a ballpark figure of how much money she has in her account or coming into her account. And guess who also has that knowledge, ladies and gentlemen? Her ex-husband, Kevin Hunter. So I'm pretty sure that at the end of the day, they're going to have to release these funds some way, somehow, because they just can't run off with this lady's money, right? There's just too much paperwork. There's a paper trail. And Wendy is not broke, and the financial institutions knows that, Kevin Hunter knows that, and everybody knows that Wendy is not broke. So there's no way that Wells Fargo can just run away with this woman's money. Now, let me make this clear. I'm not saying that they shouldn't have given Wendy's son, Kevin Jr., access to her accounts. If he's the power of attorney, he should have access. I'm just saying that I don't trust him. Anytime you leave your mama like that, and she's struggling trying to get her health together, and you're flying across the world popping bottles, and then you have a nerve to give your mom an ultimatum talking about if she doesn't get her life back together, you're not going to be in her life? Come on, man, please. I don't trust him. But anyway, guys, what I want to do here is read you all the documents. I promised you guys on yesterday that once I got all of the documentation from Wendy's lawsuit that I would come and give you guys an update. I'm pretty sure that other YouTubers have covered this. I'm just being a man of my word, coming with the documentation, and I'm going to read it in its totality, all right? So just be patient. If you don't want to hear this part, you have the right to just go ahead and just click off and go enjoy someone else's channel. But, I want to go ahead and read you all these documents. So let's go. All right, and it says Supreme Court of the State of New York, County of New York, Wendy Hunter versus Wells Fargo Clearing Services, LLC, Wells Fargo Advisors. Emergency petition for preliminary injunction, temporary restraining order, and other relief and aid of pending arbitration. Petitioner Wendy Hunter, right? By and through her attorneys, Miami Entertainment Law Group, by the way of petition against respondents Wells Fargo Clearing Services, LLC, Wells Fargo's advisors. Wells Fargo brings this special proceeding pursuant to Article 4 of the Civil Practice Law and Rules for an order pursuant to Article 63. Preliminary enjoining and restraining respondent and any of their agents, members, officers, employees, representatives, and anyone else acting on respondent's behalf from freezing all of the petitioner's accounts, including but not limited to personal, business, deferred compensation, and investment accounts, and interfering with her right to access her final assets and statements, pending a final binding decision by an arbitrator, and alleges as follows. The parties: 1. Petitioner Wendy Hunter is an individual residing in New York City. 2. Upon information and belief, respondent is a foreign limited liability company operating and existing under the laws of the state of New York. Jurisdiction and venue. Number 3, this court has jurisdiction pursuant to NY CPLR because at times material hereto respondent has continuously engaged in, operated, and conducted their business within New York State. Venue is proper in this county pursuant to NY CPLR because respondent's determination to freeze petitioner's accounts and to interfere with her financial assets along with her other material events took place within the judicial district in which New York County exists. Venue is also proper in this county pursuant to NY CPLR because at least one of the parties resides in or is doing business within New York County. On or about April 11th, 2018, petitioner and respondent enter into an asset advisor agreement and a client agreement, collectively the agreements. Upon information and belief, the purpose of the agreements is for Wells Fargo to provide brokerage cash services and to execute securities trades with petitioner accounts. Upon information and belief, respondent is in possession of several $1 million worth of funds which belong to petitioner and are currently managed by Wells Fargo and or held in Wells Fargo's possession. For more than 2 weeks, respondent has denied petitioner any access, whether online or otherwise, to her financial accounts, assets, and statements based on the advisement by petitioner's former financial advisor, Lori Schiller, that petitioner was of an unsound mind. Despite petitioner's termination of Schiller as her financial advisor due to Schiller's malfeasance in relation to petitioner's accounts and Schiller's improper conduct in relation to their professional relationship, respondent continues to rely on Schiller's advisement as support for its decision to deny petitioner access to her financial assets and statements. As additional support for its decision to keep petitioner's accounts frozen, respondent references its authority under the agreement to pause or reject instructions for proposed transaction, pending judicial or administrative remedies should they suspect financial exploitation, dementia, or undue influence. However, that provision is inapplicable in this instance for several reasons, including the fact that petitioner has not proposed a transaction for which respondent allegedly has discretion to pause or reject. And even if the provision did apply, respondent is going beyond the scope of the authority granted by the provision because respondent is completely denying petitioner the ability to access or even view, whether online or otherwise, her financial assets and statements which petitioner has requested for the purpose of ascertaining the current standing of her accounts, and which is not a transaction as contemplated under the agreements. In other words, Wells Fargo's actions and the actions of its agents have impeded and unlawfully prevented petitioner access to her property. Although pre-dispute arbitration is required under the agreements, given the imminent and irreparable harm caused to petitioner by respondent's actions, petitioner seeks injunctive relief from the court pursuant to Article 63 of the CPLR and the CPLR 7502, preliminary enjoining and restraining the respondent from denying petitioner access to her financial accounts, assets, and statements pending a final binding decision by an arbitrator. Petitioner repeats and restates the allegations contained in the prior paragraphs of this petition as if set forth more fully herein. Petitioner requests immediate preliminary injunctions and temporary restraining orders, preliminary enjoining and restraining respondent and any of their agents, members, officers, employees, representatives, and anyone else acting on respondent's behalf from freezing all of petitioner's accounts, including but not limited to personal, business, deferred compensation, and investment accounts, and interfering with her right to access her financial assets and statements. While ordinarily the function of a preliminary injunction is to preserve the status quo until a final determination upon the merits can be made, there is no question that in a proper case the Supreme Court has power as a court of equity to grant a temporary injunction, which mandates specific conduct. To obtain a preliminary injunction, a petitioner must demonstrate a likelihood of success on the merits, irreparable harm in the absence of the injunctive relief, and a balancing of the equities in the petitioner's favor. See Ruiz versus Maloney, 26 AD, blah, blah, blah. The decision to grant or deny a preliminary injunction rests in the sound discretion of the court. To establish a likelihood of success on the merits, all that is required is a prima facie showing of the right to the relief requested. Moreover, it is well settled that a likelihood of success on the merits may be sufficiently established even where the facts are in dispute and the evidence is inconclusive. The mere existence of an issue of the fact will not itself be grounds for the denial of the motion. The Supreme Court may render a declaratory judgment having the effect of the final judgment as to the rights and other legal relations of the parties to a justiciable controversy, whether or not further relief is or could be claimed. To state a cause of action for declaratory relief, a petitioner must show that there is a bona fide justiciable controversy between parties with adverse legal interest, and a judgment would clarify or settle legal issues and finalize the controversy and offer relief from uncertainty. The petitioner must establish that the dispute is real, definite, substantial, and sufficiently matured so as to be ripe for judicial determination, and the declaratory judgment will have a direct and immediate effect upon the rights of the parties. In this case, petitioner is likely to succeed in establishing her right to a declaratory judgment because there is a bona fide controversy between petitioner and respondent as to petitioner's right to access her financial assets and respondent's decision to deny her such access. Due to the adverse and legal interest between petitioner and respondent regarding this matter, a judgment will settle the legal issues and finalize the controversy. Additionally, given the imminent and irreparable financial damage directly resulting from respondent's actions, the declaratory judgment will have a direct and immediate effect upon petitioner's right to access her property. Thus, petitioner is likely to succeed on the merits of a declaratory judgment against respondent. The elements of the case of action to recover damages for breach of fiduciary duty are the existence of fiduciary relationship, misconduct by the defendant, and damages directly caused by the defendant's misconduct. In this case, petitioner is likely to succeed on the merits of a breach of fiduciary duty claim against respondent because petitioner will allege that the parties in fact have a fiduciary relationship. Respondent's misconduct and breach of his fiduciary duties includes, but not limited to, respondent's unlawful determination to freeze, withhold, or otherwise alter petitioner's access to her final assets, directly resulting in financial damages from petitioner's inability to make timely bill payments and incurring fees as a result. Accordingly, because respondent engaged in conduct that was not in the best interest of petitioner, it breached its fiduciary duty. Affirming a preliminary injunction where plaintiff demonstrated a likelihood of success on the merits by showing that defendants breached their fiduciary duty when they established and engaged in a business in direct competition with plaintiff while they were still in plaintiff's employ. Thus, petitioner is likely to succeed on the merits of a breach of fiduciary duty claim. Petitioner further submits that the potential harm faced by petitioner if respondent is permitted to continue to interfere with the ability to access her financial assets far outweighs any potential harm to respondent in being precluded from such actions during the pendency of an arbitration. If this court does not enjoin respondent, petitioner will be in default of several bill payments, including her mortgages, her marital settlement payment, her employee payroll. Thus, respondent actions, if not enjoined by this court, will threaten petitioner's financial viability. Respondent's continued interference with petitioner's ability to access her assets will not only result in petitioner's inability to support herself and her family, but also result in irreparable damage to her business and brand. By contrast, respondent will not suffer any actual harm if it's prohibited from withholding and interfering with petitioner's financial assets and statements. Under these circumstances, where the equities overwhelmingly favor petitioner, preliminary injunctive relief is necessary and appropriate. If the court does not grant the requested relief, petitioner will continue to suffer imminent and irreparable harm because respondent is impeding petitioner's right to properly manage her personal finances and to make timely payments on billing accounts, which threatens petitioner's financial viability and the financial health and safety of her family. Additionally, without the court's intervention, respondent will be free to further damage petitioner and continue to interfere with petitioner's final assets and property, which will threaten petitioner's ability to manage her ongoing business obligations. Interference with an ongoing business risks irreparable injury and is enjoinable. One factor in determining whether a harm is irreparable is the availability of legal damage remedy that will adequately compensate the applicant. But the legal remedy must be a complete, practicable, and efficient as the equitable one. Moreover, the remedy at law is inadequate when the damages are not capable of measurement or difficult to determine, or there would be a long delay in its availability. The prevailing rule is that where the rights of parties are clear, the court should interfere to prevent violation of the rights instead of allowing the rights to be violated and the wrong committed, and then remitting the party injured to a remedy at law, many times uncertain at best. In this case, enjoining respondent from freezing, withholding, or otherwise altering any and all of the petitioner's financial accounts, assets, and property would be the most complete, efficient, and practicable way of maintaining petitioner's rights. The alternative would be to permit respondent to continue to deny petitioner's access to her financial assets and allow petitioner to default on her financial obligations, resulting in petitioner's inability to pursue ongoing business endeavors and to force the arbitrator to attempt to measure petitioner's damages based on the amount of the business that the petitioner could have secured and the number of billing payments that petitioner could have kept current had she been permitted to access her assets. Thus, a legal action for damages is impracticable and inefficient when compared to the equitable remedy of enjoining respondent from continuing to interfere in the first place. The equities balance in favor of granting petitioner the requested relief. Allowing petitioner to access her financial assets will allow petitioner to properly manage all ongoing personal and business financial obligations. Absent an injunction, petitioner's financial well-being is subject to imminent and irreparable harm by respondent's actions. Respondent, however, would suffer no legally cognizable harm in being prevented from interfering with petitioner's ability to access her finances. In fact, respondent's only real opposition to petitioner having access to her funds is that petitioner will cease business with them by closing out all of her accounts, which petitioner has every right to do. Under these circumstances, where there is no evidence that injunctive relief would impose a hardship upon respondent, where the equities overwhelmingly favor petitioner, a preliminary injunctive relief is necessary and appropriate, right? Preliminary injunction prohibiting interference with shipments by suppliers to plaintiffs warranted in the absence of any proof that defendant would be harmed by the granting of injunctive relief. Preliminary injunction warranted where defendants will suffer no great hardship as a result of the issuance of the preliminary injunction. Balance of equities favored plaintiff, where defendant would suffer no prejudice or inconvenience if preliminary injunction was granted, while denial of relief could cause plaintiff substantial and irreparable harm. Accordingly, this court should grant petitioner's application preliminarily, enjoining and restraining respondent and any of their agents, members, officers, employees, representatives, and anyone else acting on respondent's behalf from freezing all of petitioner's accounts, including but not limited to personal, business, deferred compensation, and investment accounts, and interfering with her right to access her financial assets and statements pending a final binding decision by an arbitrator, and for such other relief this court deems just and proper. Wherefore, by reason of the foregoing, petitioner Wendy Hunter hereby respectfully requests that this court enter an order enjoining and restraining respondent and any of their agents, members, officers, employees, representatives, and anyone else acting on respondent's behalf from freezing all of petitioner's accounts, including but not limited to personal, business, deferred compensation, and investment accounts, and interfering with her right to access her financial assets and statements pending a final binding decision by an arbitrator, enjoining respondent and any of their agents, members, officers, representatives, and anyone else on respondent's behalf from freezing, withholding, or otherwise altering any and all assets that are currently identifiable as accounts and policies which contain funds that were removed or withheld from petitioner's own personal and business accounts, and all other funds, whether known or unknown at this time, deposited into bank and deferred compensation accounts, resulting in petitioner's inability to access her financial assets and property, preventing respondent and or their agents, including advisors, administrators, and fund managers, from removing, transferring, surrendering, selling, cashing in, hypothecating, or otherwise altering or moving any and all assets held in petitioner's name on her behalf or in the name of third parties, all bank accounts, credit accounts, deferred compensation plans, life insurance policies, annuities, and other financial, personal, and business assets, enjoining and prohibiting respondent or their agents from acting in a capacity which might affect the assets or operations of petitioner and or any other asset to which respondent might have access, where such access had already and might continue to interfere with the operations of petitioner's personal and business endeavors and or financial obligations, directing that respondent reopen any frozen accounts or assets and grant access to any accompanying statements currently identifiable as accounts and or policies which contain funds that were removed and or withheld from petitioner's accounts within 48 hours of the date of the order, enjoining and prohibiting respondent and or their agents from acting in any capacity which might affect petitioner's ability to close and or liquidate any financial assets with Wells Fargo, including but not limited to bank accounts, deferred compensation accounts, and life insurance policies, and granting such other and further relief as the court deems just and proper. Dated February the 4th, 2022. Okay, so there you have it. That's the lawsuit, and hopefully Wendy gets her accounts and all that stuff straightened out, and I'm pretty sure she's getting the hell out of Wells Fargo, and I hope the next place that she takes her, business to, that they understand her position. If she names her son the, power of attorney, that he's the power of attorney, even though I don't trust him. But legally, if he's the power of attorney, he was supposed to have access to Wendy's money. So I just hope that this situation clears up really fast and Wendy gets to go back to just living her life and being able to pay her people, being able to take care of her family and pay her mortgages and things of that nature. But anyway, guys, I'm going to let this go and let y'all have that in the comments. Drop down and let me know what you think about this whole particular situation. Don't forget to like, comment, share, and subscribe, and I'll get with you in the next video. Thanks for watching. Peace.